Washington State has very strong campaign finance laws. The public has a right to know how campaign and political donations are used. And today we're announcing a significant campaign finance lawsuit against Tim Eyman, against a for-profit signature gathering firm known as Citizen Solutions, and also one of the principals of that firm, Citizen Solutions, William Agazarm. Our lawsuit alleges an elaborate web of unlawful financial transactions. The result, Tim Eyman personally profited from these transactions and caused inaccurate and misleading reporting. These defendants demonstrate contempt for our campaign finance laws, and they will be held accountable. Tim Eyman and his for-profit company, Tim Eyman Watchdog for Taxpayers, could face at least $1.8 million in penalties. Additionally, we will request the court to have Tim Eyman reimburse $308,000 in contributions that went to his personal use. Citizen Solutions and William Agazarm face penalties up to $924,000. Now, as some of you will recall, there was a 2002 court judgment that barred Tim Eyman from serving as a treasurer for any political committees. That obviously did not prevent him from engineering this elaborate scheme. Tim Eyman still managed to weave an elaborate web of financial transactions to hide campaign funds, enrich himself, while keeping his contributors and the public in the dark. Consequently, I'm also asking the court for a specific injunctive relief. I'll be asking the court to permanently forbid Tim Eyman from participating in or directing financial transactions of any kind for any political committee. In addition to enriching himself, Tim Eyman effectively duped his own contributors who thought they were supporting one initiative, Initiative 1185, but ended up supporting a different initiative, I-517, and Tim Eyman personally. I'd like to make some introductions of some important folks who have been involved in this case for some time through the PDC and will be involved in the case as it moves forward. So I'm joined by two assistant attorneys general, Walter Smith, right here to my left, and Jeff Sprung next to him. I'm also joined by our investigator, Tony Perkins, who's done significant work on this matter for some time, and also someone that many of you know, that's Ann Levinson, the chairperson of the Public Disclosure Commission. And just before I go any further, as I think many of you know and you covered in reporting some time ago, the PDC put together an extensive report with these allegations that was then turned over to our office. And so we would not be here today having this press conference with this announcement had it not been for the work of Ann and her team who really provided critical information to help us further the investigation as well. So it was in August of 2012, I'll give you a little bit of background, that the PDC received a complaint about Tim Eyman and two of his political committees, Voters Who Want More Choices and Protect Your Right to Vote on Initiatives. The PDC staff, as I mentioned, investigated and presented their findings in September of 2015. The investigation found evidence of multiple violations of state law, and as I mentioned, referred the case to my office. And I'll speak a bit about the PDC process shortly. Once we began our own investigation in the Office of Attorney General, we were, as you know, stymied for months by Tim Eyman and the for-profit signature gathering firm involved, Citizen Solutions. We issued our subpoenas in November of 2015, but received only a smattering of records. Much of that information that we did receive, that limited information we did receive, was heavily redacted or censored. They based those redactions on privacy rights that they refused to actually defend in court. Those were not real privacy rights, they simply said that, but they actually never made those arguments to the court. Because they ignored our subpoenas, we ultimately, as an office, had to go to court and have judges order Tim Eyman and his committees to comply. Even then, they refused to meet the court order deadline, and it took a contempt motion from my office to force them to comply with those subpoenas. Moreover, the courts eventually ordered Eyman and Citizen Solutions to pay back Washington taxpayers for frankly wasting the time of the folks in my office. They paid a total of more than $33,000. As a result of the court's actions, we were able to continue our investigation, resulting in today's lawsuit. So I'm just going to try to briefly walk through what transpired. We have a couple visual aids. I'll refer to this one immediately to my right. It can be a bit complicated. I know it's been reported, but anytime you have an elaborate web like this of financial transactions with lots of different names and entities, it can get a little confusing. We're hopeful that this chart will certainly help me in trying to navigate this. Hopefully it'll help you as well, but we're also happy to answer any questions, obviously, at the end about it. So here's where we started. At the top here, you have voters want more choices, save the 2/3. That's a political committee with 1 treasurer and 3 officers. One of those officers was Tim Eyman. So that's where we start. That entity was created to support Initiative 1185. That was an initiative that would have required a 2/3 majority for legislative actions raising taxes. On April 2nd of 2012, Tim Eyman signed an agreement on behalf of that committee, the Voters Want More Choices, with for-profit signature gathering firm Citizen Solutions. They're the big circle right here. Citizen Solutions, they did this to provide signatures to qualify 1185 for the November 2012 ballot. So payments from the committee, the Voters Want More Choices, and other contributions to Citizen Solutions totaled more than $1.2 million. And as you can see, $623,000 came from Voters Want More Choices. That's the entity that Tim Eyman was involved in. Immediately after the signatures were delivered, Tim Eyman and his for-profit company, Tim Eyman Watchdog for Taxpayers, you find them down here, they sought and received the $308,000 from Citizen Solutions. There is no written agreement that exists related to this transfer of more than $300,000 from Citizen Solutions to Tim Eyman. The only thing we have in writing is an email chain from July 8th between Eyman and Agazarm, the principal of Citizen Solutions, referencing the payment, in which Agazarm wrote, "The immediate goal is to get you paid. You, Tim Eyman, get you paid." The payment was delivered via wire transfer on July 11th, 2012, 4 days after the signatures were delivered. None of this was reported to the Public Disclosure Committee. That's concealment, and that's against the law. Eyman also did not tell, back up here at the top, Voters Want More Choices about this payment. So as a result, when Voters Want More Choices filed 5 PDC reports, they were inaccurate and misleading because the money that went to Eyman was not accounted for. That $308,000 went to Eyman. That was not accounted for in any PDC report. The public was in the dark about that entire transaction. So that's against the law. Each of those reports is a separate violation. Now, of the $308,000 that went to Tim Eyman, I'm going to focus on that for a minute. That $308,000, at least $100,000 of that, coming over to this box, at least $100,000 of that went to Tim Eyman's living expenses, which Tim Eyman admits. We don't know exactly how he spent that money, he won't say, but we intend to find out. When we do, potentially every time he spent that money is an additional violation beyond what we're already alleging in our complaint. Okay? Each time you use those dollars, that can be a separate violation. Now, the same day he received the money from Citizen Solutions, Tim Eyman made the first in a series of payments to a Virginia-based advocacy group known as Citizens in Charge. So now we're coming down our chart down here. So again, he's got $308,000 bucks. $100,000 goes for living expenses, right? $200,000 is going to go down to this entity down here. So he made the first in a series of payments to that entity totaling $200,000, and that was to sponsor signature gathering for a different initiative. So keep in mind, folks are donating way up here at the top for one initiative. Now money is going for an entirely different initiative that the public has no knowledge of, nor do the donors who donate up here at the top. That new initiative is I-517. That initiative would have set penalties for interfering with signature gatherers or signers. And this money was then sent to Citizens in Charge by Eyman. Citizens in Charge did spend the money to pay for signature gathering for I-517. They sent those signatures to another Eyman committee, Protect Your Right to Vote on Initiatives, and that committee was dedicated to advocating for I-517. The value of those signatures, $182,000. So instead of reporting Eyman as the source of this in-kind contribution, Eyman directed the committee to report Citizens in Charge as the source. There are violations here as well. The major one is concealing the source of that contribution, valued at $182,000. This also led Protect Your Right, that organization, to file inaccurate and misleading reports to the PDC, and again, each of those reports is a violation of the law. What I'm going to do now is turn to Ann to speak to the PDC's tremendous help. I just really want to reemphasize, We would not be bringing this case had it not been for the PDC. The PDC is a critical partner for us in enforcing our campaign finance laws. My team and their team work very closely together on cases big like this and cases relatively small, but it's that teamwork that has enabled us to be here today. So I just really want to thank Ann and the entire team for their really fantastic work that helped set this up. Ann? Thanks.
Thank you, Bob. Good morning, everyone. I'm Ann Levinson, Chair of the Washington State Public Disclosure Commission. For those of you who don't know, the Public Disclosure Commission is the state agency responsible for overseeing and enforcing our state's campaign finance and disclosure laws. I want to thank the Attorney General's office, Attorney General Ferguson, in particular, for taking the action that he's announced here today. After our staff's investigation into these matters, the Commission unanimously referred these cases to the Attorney General and requested that he take any and all appropriate legal action that he has within his authority. The Commission also requested that the Attorney General's office expand the investigation and the prosecution of this matter to address any actions taken by Mr. Eyman and his colleagues prior to or subsequent to the time of the period covered by the PDC complaint, and to include any additional charges that were warranted by their review and investigation of this expanded time period. We specifically said in our referral that whether it was a civil sanction or a criminal sanction, that we wanted the Attorney General to vigorously enforce and prosecute these matters. Our decision was based on a very detailed staff investigation, which Mr. Perkins led at the time, as well as on Mr. Eyman's refusal while being interviewed under oath to answer questions about his compensation, and his refusal to produce records subpoenaed by the PDC until he was forced to by further enforcement action. The Commission was extremely troubled that it appeared that Mr. Eyman intended to hide from the public the sources of funds and the actual purpose for which expenditures were made, and to further conceal that he had used funds solely for his personal use. Given his creation of multiple LLCs and committees, his explanations that he did not intend to hide the sources or uses of funds strained credibility. Nor, given his many years of initiative activity, could he legitimately claim that his actions were due to a lack of experience in filing of the required campaign disclosure reports or a lack of understanding of the allowable uses of campaign donations. The Commission advised the Attorney General that Mr. Eyman's actions and operations appeared to be an intentional disregard for campaign finance and disclosure laws which were enacted by the voters of our state to put a stop to conduct such as this. It also did not go unnoticed by us that the purported purpose of his initiatives was to protect the very public that he was harming by his violation of these laws. Considering the possible multiple violations of the law, as well as Mr. Eyman's prior history with the PDC, his frequent and repeated use of the initiative process, and the likelihood of an intentional ongoing pattern over multiple years, the Commission felt strongly that this was one of the more egregious matters we had seen, and that prosecution by the Attorney General was called for to enforce compliance with the law in a manner that would hold Mr. Eyman accountable for his actions, deter future misconduct, and protect the public. Our state's campaign finance and disclosure laws are premised on the principle that the public deserves to know who is funding political campaigns, who is spending money to influence their vote. Mr. Eyman has an obligation to obey the law. When he or others do not, the Public Disclosure Commission and the Attorney General have an obligation on behalf of the public to ensure that all necessary steps are taken to preserve the integrity of our electoral system. I want to thank the Attorney General for moving forward with this prosecution. I want to thank the team for doing such a tremendous job and for partnering with the Public Disclosure Commission on behalf of the public.
Thank you, Ann. Thanks very much, Ann. And just before we take your questions, we have, in this office, I've invested greater resources into enforcing our campaign finance laws. And we saw the benefit of that in the case against the Grocery Manufacturers Association, in which a judge in Thurston County issued penalties of $18 million, an additional $1 million plus for our costs and fees. We had to take that case to trial, and that's a significant use of resources to take a complex case like that to trial. One thing about the GMA case that really angered me was their conduct was intentional. They were arrogant in how they conducted their business, the GMA. And that's frankly why I took them to court and did not settle that case. And I see similar patterns here. This conduct is intentional, it is willful. Tim Eyman knew what he was doing, and he personally profited from this. That is not okay, and that is why we now have a team in place in our office who can focus on these cases and bring them to trial, and we have the resources to do that. With that, why don't we start with some questions here? I know there may be a couple folks on the phone, so for those on the line, we'll do our best to repeat the question here so you can hear it, and we'll start, Joel, with you.
You mentioned in terms of the $100,000 to Eyman for his personal use that you're going to find out how he spent it. That kind of inspires a question, maybe something that chess player does not particularly want to answer, but is this a investigation of work in progress, and if so, what are your next moves?
So the question goes to, hey, is this investigation a work in progress? What are our next moves? And you mentioned the $100,000 specifically that Tim Eyman used for personal expenses, living expenses, but he would not elaborate on that. I think what I can say to that, Joel, is like any litigation, we'll go through a discovery process. We seek documents. We anticipate additional information will come forward, and in any litigation, you adjust to that new information. So I'm confident this case will be no different in that regard. We're at the very first stage, right, of formally filing our complaint. I should say, by the way, which I'm not sure if I did, that we actually filed just moments ago in Thurston County Superior Court. So that complaint has just been filed, and we have copies of it available, I believe, as well afterwards. So look, we go where the law takes us. We go where the information we gather from a lawsuit takes us. And like any litigation we bring, we obviously adjust accordingly if that's warranted.
A quick follow-up.
Yeah.
As you have worked with the 76-page report from the Public Disclosure Commission and so on, would you have any observation, and also having drawn more intensely into campaign finance, would you have any observation about the amount of resources that have been given the Public Disclosure Commission and whether it needs more?
Okay, so the follow-up question is one you always have to be careful about. The follow-up question is asking about the PDC and essentially mentioned the resources that we've put in the AG's office to campaign finance. Do I have any comment about the corresponding draining of resources to the PDC? I'm sure Ann will want to add something, but I'll be the warm-up act for her on this. Yes, look, our laws only have meaning if they can be enforced. Great, you have laws on the books, fantastic, but they only have meaning if you're willing to enforce them and you have the resources to enforce them. And the PDC, through no fault of their own, does not, in my estimation, have the resources that they deserve to ensure the public knows where campaign funds are being spent. So I think it's also fair to say, Joel, that this case is a good example, right? The PDC for a large case can and should send to the AG's office, right? We have certain penalties we can seek that the PDC cannot. So I want to make sure we had resources, right? A team in place that can bring a complex case to trial. But I'll let Ann speak maybe more about the PDC specifically and the resources they do or do not have.
Thanks, Bob. Thanks for the question, Joel. I couldn't agree more with Attorney General Ferguson. The PDC is an independent agency, and it needs to vigorously enforce the law in a nonpartisan manner, and it needs to do so quickly and thoroughly in a way that best serves the public, particularly during the height of campaign season. And the PDC is woefully underfunded in terms of having the sufficient investigative staff it needs. As well, I would say, Joel, the PDC's limitation on a penalty authority of only $10,000, it's clear in a case like this that the PDC needs greater penalty authority when you have egregious violations of the law, patterns of misconduct, concealment, use of campaign funds for personal use, such as we see here in this case. So I appreciate the question, and we will continue to partner with the Attorney General to move these cases forward vigorously, and we are very appreciative that he has provided additional capacity as well as the breadth of authority and the significant approach to both the civil and criminal side of this case that he can take that's beyond what the PDC has the statutory authority to do.
Yes.
Can I ask, you mentioned this is one of the most egregious cases you've seen. Can you
Right.
elaborate on that? And then my second question that would tie in the AG's office as well is how did the two investigations differ? Did you find new evidence or additional evidence?
Can you repeat that for them?
Sure. The question was that I had mentioned that this was one of the more egregious violations the PDC had seen, and to explain why that might be. I think if you look at these charts, you will see here the intricate web that Mr. Eyman wove here, and this was by no means a mistake. This was not accidental. This was not one time. This was not due to the complexity of the law or the fact that he was inexperienced. This was intentional. It was a pattern, and it was done in a way that really did a great disservice to the public. The public has a right to know who's influencing their campaigns and elections. Donors have a right to be ensured that their money is going to be used consistent with the law. And what you see here before you today is one of the more complicated and woven in such a way that it is crystal clear that this was not an accident or this was not a one-time occurrence.
And then I think the second, you had a second question there, I think, which I'll repeat. I think the second question went to the original PDC investigation, then our further investigation, how those two relate, were there new things that came out? I think the best way to summarize two complex investigations, right, is that, yes, we were, by having to go to court, right, to get documents, we were able to get additional documents from Tim Eyman and his committees. I think it's fair to say that those documents, bank records, for example, that we received reinforced the facts laid out by the PDC report. So provided greater detail around the PDC's initial pretty detailed report itself. So it essentially confirmed what we saw in the PDC report, provided greater specificity, specific records that helped us in bringing the complaint. Yeah.
Can you just, you alluded to it, but can you outline the specific penalties he's facing?
Yes.
And for people who gave donations, any chance of restitution?
So the question goes to detailing the penalties. And so we actually have, which we're going to hand out, a press release that details very specifically, because it does get pretty detailed in a hurry about the violations and how you get there. Let me give you a couple of high-level examples of how we get to approximately $2 million. And by the way, it may exceed that before we're done, but we view the $2 million as a starting point. So for example, and look at the $308,000 that went directly to Tim Eyman. That amount was concealed, okay? And as we saw in the GMA case, they concealed, I think it was $11 million or so, right? And so a judge in a case like that can assess a penalty for that concealment up to the amount of money concealed. So taking just this as an example, that $308,000, we are saying to the court, he concealed $308,000, you need to penalize him that $308,000. Now under Washington state law, and we saw this in the GMA case, the court can also triple that penalty if the court determines that the conduct was intentional. So in the GMA case, for example, there's essentially almost a separate trial on intentionality. We prevailed, so the judge tripled the $6 million penalty. That's how we got to $18 million. So we're also asking the judge, we believe we have an extremely strong case that this is intentional conduct. So we're going to be asking the judge to take the $308,000 and triple it, okay? So there are also specific reports that were not filed. Those can have smaller sanctions, but you can triple those as well. So because they are detailed and numerous, we do have that in our press release that just lays them all out in terms of what we're asking for. The total is about 1.8, I believe. In addition, that $300,000, we're saying he needs to, essentially needs to be returned. I'm not sure I can answer whether or not it ultimately goes back to individual donors or not. I'm not sure if our team can speak to that or not, but we can try and get back to you on that if, yeah.
Is there a chance of restitution to the donors?
Do we know, can we speak to whether there's a chance of restitution for donors? Are we able to speak to that? We'll get back to you on that. I don't think the team wants to go in that level of detail now, but let's take a look and we'll get back to you on that. Essex.
Eyman does have a lot of supporters.
Sure.
Critics will say that you, a Democrat,
Oh, yeah.
are trying to put him out of business.
Sure.
Are you trying to put Tim Eyman out of business?
Yeah, so the question from Essex is that Tim Eyman has many supporters, which he certainly does, and that critics will say that I'm trying to put him out of business. What I'm trying to achieve is to ensure that Tim Eyman follows the law. That's what he's got to do. If he's not going to do it, he's going to end up in court. That's what's happening here. So, look, his supporters should know that there were donors to Tim Eyman who thought they were donating to one initiative And that money went to his personal living expenses and to an entirely different initiative, right? That's what those supporters should know. To say it's deceptive is an understatement. So look, what he has demonstrated a singular inability to lawfully handle financial transactions. That's why court said he could not be a treasurer back in 2002. That did not prevent him from engineering this elaborate scheme of financial transactions. And so yes, we'll be seeking injunctive relief as well besides the financial penalties. And as I mentioned, one aspect of that injunctive relief, we may have others, is that he not be allowed to be involved in any financial transactions with any future political committees in the future to avoid exactly the situation. Did you want to add something to that, Ann? Yeah.
And just to follow up on Essex's question, the PDC and the Attorney General cannot and should not take into account whether the individual involved is politically popular or whether the initiatives that he's espousing are politically popular. All the more so, we have an obligation to ensure there's robust enforcement in the face of that. It should not matter whether there's broad support or not for the initiative measures. What matters is whether he obeyed the law, and that we hold everyone equally accountable for doing so.
Are there only civil penalties associated with this? Is it not criminal?
Good question. So the question is this simply civil, or is there a criminal aspect to it as well? So thanks for asking. This is a civil matter. These campaign finance laws are civil in scope. I think that Ann mentioned that with the original PDC report that they mentioned that that the AG could consider pursuing civil or criminal. This is civil. We have in our office set up a screen between those folks who can examine this on the civil side. That includes the folks who are here, right? And any potential action on the criminal side. We don't speak about any ongoing investigations, so I can't speak to that. Moreover, I can't speak to that because I've been screened from the criminal side. We have to, as a law firm, keep those things separate. So I'm on the civil side, so I can have conversations with my team on the civil side. But I, for example, and everybody you see here from my office, we are screened from any conversation on the criminal side. That means literally I cannot have any conversation, will not be involved in any decisions there, because we need to keep the evidence, the information we're receiving, totally separate. So I just want to emphasize.
Who do we say to find out if there is one?
So you can contact Peter afterwards, but I'm sure the answer is we do not speak about ongoing investigations, as you know. But Peter can get back to you afterwards and check in with on the folks on the criminal side, see if there's anything further. But we do not speak about ongoing investigations or even whether one exists. I want to emphasize that. Why don't we go to, if there's anyone on the phone who might have a quick question or two? And we're happy to stick around, by the way, afterwards and answer individual questions. Is there anybody on the phone who has a question? If so, please introduce yourself and go right ahead.
Yeah, this is Jerry Cornfield. Just one question you mentioned is provides new details from the PDC and builds on their investigation. They had a chance to depose Tim Eyman back in 2014. Did your team have anything more recent than that? And if so, what did Mr. Eyman provide you?
I guess I'm not sure, Walter, if you want to add. So there was we deposed Tim Eyman on Monday, I believe. Is that correct? Just earlier this week.
That's right.
And so is there, I'm not sure we have anything additional at this point for you, but yes, we did take an additional deposition from Mr. Eyman as well. And as the case goes forward, I think additional information will come out. But I think to the question earlier.
Can you share anything about how he responded to each of all these allegations you made?
Walter, are you able to speak to how he responded in general to the allegations? Are you able to speak to that? We'll go ahead and take the microphone and introduce yourself. Yeah.
This is Walter Smith with the Campaign Finance Unit. Mr. Eyman's deposition was our first opportunity to ask him questions about some documents we obtained in response to subpoenas issued after the PDC referred this to our office. I would say up to now, Mr. Eyman has been opposed to the state's theory of this case that's been clear from the PDC referral, the nature of the allegations and concerns about concealment. He's certainly, he does not see it the way that the state does, and so that's why we're proceeding now with our complaint.
Any other questions from anyone on the phone? If not, for those here, we're happy to, as I mentioned, to stick around and take questions one-on-one if you have them. I want to thank you all for being here. And again, thanks to my team for their hard work, and especially the team from the PDC who did extraordinarily detailed work that really brought this case to us in a way that we could move forward. Thank you all very much. Hope you all have a great day.